Welcome to the ARPA Benefits Compliance Updates and FAQ. Thank you all so much for joining us today for Part 5. Our Benefits Compliance team will be moderating today's call, led by Jill Brooking. At the end of today's call, please post your questions in the Q&A as opposed to the chat, and we will try to get to as many of the Q&As as we can in the time allotted after today's main discussion. If you are unable to stay on the call, please note that today's presentation is being recorded and will be emailed out tomorrow. The recording and the slide deck from this webinar will be posted to the nfp.com latest insights page under webinars/training. At this time, I'd like to introduce our speakers for today's webinar. Joining us today are Patrick Myers, Vice President and Counsel, Beth Allen, Vice President and Counsel, and Diane Cross, Vice President and Counsel for NFP's Benefits Compliance Department. We are very excited to have them speaking with us today, and it is my great pleasure to hand the call over to our speakers. Beth, the floor is yours.
Thank you so much, Leanne, and thank you everyone for joining us today for part 5 of our ARPA webinar series. Most of you probably know that we are having this webinar after receiving guidance from the IRS last week, specifically on the COBRA premium assistance. So as always, this is not tax or legal advice. This is just us providing you with some informational or general guidance that is current as of right now. So just to jump in to what we're talking about today, because we know that many of you, logged onto this call because you are intimately aware of the ARPA COBRA Premium Assistance, we're not going to belabor a brief overview of those requirements, but just because we sometimes deal with people who may be newer to our webinar series or who have not had as much occasion to be involved with what's going on this, we are going to, like I said, start with a brief overview of the requirements of the law. And then we're going to address 8 major concepts that we received through IRS Notice 2021-31. Okay, now I will say up front that this is ambitious for 90 minutes. Okay, I'm going to bring up later the fact that that guidance actually included 86 different questions and answers. So as you can imagine, that could be an all-day training that we are condensing into 90 minutes. So please bear with us as we go through that information. And then we'll end off briefly with some final thoughts on implementation of the COBRA Premium Assistance as well as resources. So I'm going to go ahead and get started by kicking it over to Patrick to give us that brief overview of the ARPA COBRA Premium Assistance provisions.
Thank you, Beth. Hello, everyone. Thank you for joining us. We're going to go over a review of this material in the form of a step-by-step compliance process. And the first step we want to ask ourselves is, who is responsible for providing premium assistance to participants and claiming the tax credit as a premium payee? Well, as the slide indicates, if you're a fully insured employer subject to federal COBRA, the employer is responsible. If you're a self-insured employer subject to federal COBRA, again, the employer is responsible. If you're a single employer plan subject to state continuation but not federal COBRA, then the insurer would be the one responsible. If it's a multi-employer plan, for instance, like a union, then the plan itself or the trust that holds the plan is responsible. Now, we don't have guidance as to who is responsible for a MEWA, and hopefully we'll get some more guidance on that matter, but that in a nutshell is who is responsible for providing the assistance. Next slide, please. So the second step is to determine who those assistant eligible individuals are. I think for the purposes of our discussion here, we'll just call assistant eligible individuals as AEIs. There are 4 elements that need to be met in order for a person to be an AEI. The first element is that the initial COBRA triggering event has to be either an involuntary termination of employment, more on that later, and a reduction of hours. Now, involuntary termination of employment has to be involuntary, but the reduction of hours can be either involuntary or voluntary. The other thing I'll note at this stage of the presentation is that involuntary termination of employment for gross misconduct will not qualify a person for premium assistance. The second element is that the person is still within their maximum coverage period. Because we're dealing with involuntary terminations and reductions of hours, that coverage period is generally going to be 18 months for federal coverage. State continuation is going to vary, but that's the general rule. And we also want to make a note that this includes new COBRA qualified beneficiaries. The third element is that the person is not eligible for other group coverage. And I think we're going to dip into that a little bit later on as well, but that's something to keep in mind. And then finally, the person cannot be eligible for Medicare. Next slide, please. So once we've determined who the AEIs are, what do we do then? Well, step 3 is that you need to send those AEIs the required notice. The DOL has published model notices that are available on their website that can suit this purpose. There is a model general notice and COBRA continuation coverage election notice, a model notice in connection with extended election periods, a model alternative notice, and a summary of COBRA premium assistance provisions under the American Rescue Plan Act of 2021. I want to note that the summary is actually included with the other notices when you send them out. A little bit more on that later. Next slide, please. So who do we send these notices to? If you're an AEI and you're currently enrolled in COBRA, you should receive the model notice in connection with extended periods. If you're an AEI that's not currently enrolled in COBRA, but still within the maximum coverage period, you're going to receive the model notice in connection with extended election periods. If you're a qualified beneficiary who has a qualifying event between the 1st of April and the 30th of September of this year, you receive the model general notice and the COBRA contribution coverage election notice. Now, if you're a qualified beneficiary and you're enrolled in continuation coverage through a state continuation only, you get the model alternative notice. And one thing I will add here is that in some states, they may have model notices particular to their particular state and healthcare continuation rules. Wisconsin is a good example of this. So it might be a good idea to check your states to make sure that's whether or not that's the case. And I also want to note again that the summary of the COBRA premium assistance provisions should accompany any of these notices when they get sent out. Next slide, please. Now, finally, when do they need to be sent? You need to send the notices by May 31st. For those AEIs not currently on COBRA, but still in the maximum coverage period, they need to get that notice this week because this is going to be May 31st is Memorial Day. So you want to make sure the postmark is on or before Saturday, May 29th. Employees then have 60 days to elect and postmark return forms. And that is 60 days from the day they receive the notices. And the coverage can be retroactive to April 1st. Qualified beneficiaries will need to return a request for treatment as an assistance eligible individual or AEI, which is on page 2 of that summary document that should go with every notice. And if you are currently not on COBRA, then the model notice explains and to ask you to return the request for treatment as well as a COBRA election form. So you're sure to elect COBRA coverage going forward. Next slide, please. So the next step is who pays for the premium assistance? Well, first of all, employers should work with their carriers and COBRA vendors in order to make sure this thing runs smoothly. AEIs should not be charged the premiums from April through September. AEIs are considered to be paid in full. This may depend on the AEIs completing and returning that request for treatment form. The entity responsible for paying the premium is entitled to the tax credit. And as we discussed earlier, that's going to be either the carrier, the employer, or the plan, depending on what kind of COBRA there is or continuation is and what kind of plan it is. Note that an employer with a fully insured plan subject to COBRA will likely have to front the premiums to the carrier for assistance eligible individuals and then receive the credit. Next slide, please. And finally, step 5, you send the notice of expiration of premium assistance towards the end of the premium subsidy period. This will notify AEIs that the COBRA premium assistance will end soon and will give the AEIs the date that it will actually end. The statute requires that this particular notice be provided within 15 to 45 days before the date of the expiration of the COBRA premium assistance. It's not required, however, if an AEI becomes eligible under another group health plan, excluding accepted benefits, QS, EHRA, or a health FSA, or if they become eligible under Medicare. Next slide, please. And finally, how do you apply for the payroll tax credit? In step 6, we are reminded that the credit is calculated each calendar year quarter in an amount equal to the premiums not paid by qualified beneficiaries who qualify for the premium assistance in that quarter. Your credit is limited to the amount of the Medicare tax, and it can be advanced through the end of the most recent payroll period in the quarter. The amount of the credit equals the amount of the premium plus administrative fees, which is usually 102% of the cost of the premium, just like under normal COBRA circumstances. If the employer pays more in COBRA premium assistance than it owes on employment taxes, then the IRS refunds the difference. Next slide, please. And so now I'm going to kick it off to talk about the meat of the new guidance, and I'll give it to Beth and Diane.
Thank you so much, Patrick. That was a nice, fast, and furious overview of the requirements under the COBRA ARPA premium assistance and what that requires. And like I said, we're now going to turn our sights to the IRS's guidance that we received from Notice 2021-31. Now, I will say up front that I've been kind of keeping an eye on the Q&A, and you all have already asked a bunch of good questions, but a number of them are going to be, discussed in the guidance that we're about to discuss. So to kick it off, just to let you know, the guidance we got from the IRS was Notice 2021-31. They released it last Tuesday, May 18th, and it really does provide clarification on some of the concepts surrounding the COBRA premium assistance and what was provided through the ARPA. As I mentioned, there's 86 questions and answers that are included as a part of this guidance, but it also starts off with kind of a background section that really gives a summary overview that is pretty much information we know, but there are a couple of little, Easter eggs in there as well. So when we were trying to determine kind of how to present this information, we thought it best to kind of focus on 8 major compliance concepts, if you will, that allowed us to kind of group some of the questions and answers together. And so these 8 subjects that you see on the screen now are the 8 subjects that we are going to address in as much detail as possible. And for each of those concepts, we're going to discuss the guidance kind of in a specific way. So we thought it would be a good idea to identify the guidance that was expected, meaning that it wasn't really like a shocker. We kind of all understood that this is the way that it would work. But then we're also going to look at the guidance that was more nuanced. And when I say nuanced, I kind of mean that it might be kind of that we understood what the requirement was, but the IRS guidance gave us, let's say, additional examples or clarifying guidance about how it would apply. And then that last group of unexpected guidance, I really wanted to label shocker or shocking, but that is stuff that we maybe did not see coming or that might be counterintuitive to how employers normally think about these type of subjects. And so with each of the concepts, we are going to provide kind of this expected, nuanced, and unexpected guidance. And then we're going to end each section with the discussion of the bottom line and takeaways, right? As I mentioned, this is a lot of information, okay? And so I think that bottom line kind of gives you an idea of what you need to take away from each particular major concept, as well as a few different points that we'll make as you are implementing the COBRA premium assistance. And then finally, because we know a lot of you are going to want to follow up on this, and because we're going to be going pretty fast through a lot of this information, we've taken the step to make sure that we include the actual question and answer that we feel like corresponds with the guidance that we are indicating. So when you see that kind of parenthetical with a Q and a number, it's actually the question and answer that the IRS provided. And so I'm going to welcome Diane. Oh, sorry, real quick. Acronyms. We use a lot of them. I put this guide here just so that as you're going back through the material, you know that, the different acronyms that I used, these are what they are. I think most of them are pretty understood. That premium payee maybe is an introduced term that we got from this guidance. And that really is just the entity that Patrick already mentioned is the one that's going to be entitled to the credit and also provide that premium assistance to AEIs. And so that's there for you. So now I'm going to invite Diane to talk about concept 1.
Thanks, Beth and Patrick. I appreciate the introduction and the overview of the COBRA premium assistance as it relates to ARPA. As Beth mentioned, I'm going to kick it off by talking about some guidance we received on concept 1, which we have as employer involvement or obligations as it relates to the premium assistance under ARPA. So next slide, please. And as Beth introduced the format of the content that we're sharing today, I'm going to first let's talk about what we expected, or what was generally understood prior to the guidance being released. And this is that the FAQs that we recently received last week does reiterate that the premium payee, and that is, as Beth just mentioned, the entity that's responsible for paying the premium, that is, and that entity is also entitled to the tax credit. And that's the employer for plans subject to federal COBRA. So that would be both self-insured and fully insured plans that are subject to federal COBRA. And then it is the insurer for plans that are subject to state continuation. In addition, the FAQs confirmed that COBRA premium assistance is available for health reimbursement arrangements, as we have previously understood, given that the premium assistance is available to group health plans and an HRA is a group health plan. Now, the nuanced information, what we have here is that even in situations where COBRA qualified beneficiaries normally pay the insurer for federal COBRA coverage directly, the employer is still obligated to pay the premium. And that is reiterated a little further on the FAQs on question 70. Now, the employer cannot obtain the credit if they are only subject to state continuation. And if a third party pays an AEI's premium, so for an example here, a charity pays the premium for an assistance eligible individual, the premium payee should still reimburse the AEI unless there is an assignment of rights to the third party. So that was an interesting FAQ that we received recently too. Now, for the unexpected guidance, if an employer is no longer subject to federal COBRA due to a reduction in employees, the employer is still required to provide ARPA premium assistance to AEIs who experienced their triggering event while the employer was subject to federal COBRA. So I believe in monitoring the Q&A, we've already received a few questions on this issue, in that if there's fluctuation on whether the employer is subject to COBRA, what responsibilities follow? So we're going to kind of hammer this home a little bit with an example. So next slide, please. All right, so here's the clarifying guidance we received. If an employer is no longer subject to federal COBRA due to a reduction in the number of employees, they're still required to provide the ARPA extended election and premium assistance to individuals who experience a reduction of hours or involuntary termination while the employer was subject to federal COBRA. So we're going to go through an example, but this keep in mind that eligibility and employers subject to COBRA based on the previous year's employee count. So that's something to keep in mind here. So the example kind of goes through an employer who would fluctuate in size from year to year that would trigger being subject to COBRA in 1 year, subject to federal COBRA in 1 year, but maybe not in the next. So our example here says that based on the number of employees from 2019, an employer is subject to federal COBRA in 2020. There was a drop in the number of employees, and now the employer, so in 2020, there was a drop in the number of employees, and now the employer is not subject to federal COBRA in 2021. So a lot of numbers being shared here, but remember, we just looked to the previous year's employee count to determine whether an employer is subject to COBRA. So we have fluctuation here. So in 2020, an employer is subject to federal COBRA. In 2021, the employer is not subject to federal COBRA. And an individual in this example was involuntarily terminated in November of 2020 when the employer was subject to federal COBRA. And here the guidance says that because federal COBRA applied to the employer at that time, the individual was involuntarily terminated. The individual is an AEI and eligible for federal COBRA and premium assistance. So it's a snapshot here. What we're looking at is it's determined as of the employer status at the time the qualifying event occurred. So this could mean that an employer that is now only subject to state continuation may have to deal with a special enrollment period for an individual if the qualifying event occurred while the employer was subject to federal COBRA. And then taking it one step further, while it's unsaid, but we assume that this now small employer would have to provide assistance to eligible employees who experience a reduction of hours or who experience a reduction in hours or involuntary termination on or after April 1, if state continuation applies. So bottom line there is that even though the employer is not subject to federal COBRA, that ARPA premium assistance still applies in certain circumstances to state continuation. All right, so next slide, please. Okay, so what are some takeaways here? Bottom line, employers subject to federal COBRA are ultimately responsible for complying with ARPA COBRA premium assistance provisions, but even employers subject to state continuation may have to play a slight role, okay? Reiterate that the entity who pays the credit, this new term that was introduced from the most recent FAQs, the premium payee, is set by the law. Employers may still need to work with the insurers to achieve this, and that's especially true if there is normally any direct payment of premiums to insurers. And then situations involving multi-employer plans may need assistance from counsel here. Okay, next slide, please. All right, so before we get into concept 2, just want to make sure we're answering the questions that did come up in our Q&A so far, in that when the employer size fluctuates from year to year, you're really going to want to pay attention to whether or not the employer was subject to federal COBRA at the time the qualifying event occurred. So moving into concept number 2, assistance eligible individual, AEI eligibility. And next slide, please. This is a topic that is a heavy hitter on dissecting obligations as it relates to administering the ARPA premium assistance. So what did we expect to receive from these FAQs? An AEI has to be a qualified beneficiary under federal COBRA rules, and that means that the individual must have been covered under the plan the day before the qualifying event and must be a spouse or child. And we're going to elaborate on this because, well, it merits discussion. So put a pin in it, because we'll talk about it in a slide or two. Late or unpaid premiums for retroactive COBRA does not impact one's eligibility as an AEI. That was a specific FAQ that was provided, but this isn't something that was unexpected. And none of the other COBRA qualifying events besides reduction in hours or involuntary termination will trigger an AEI status, and this includes death. So as you may be aware, there were a few questions surrounding employee death, and the FAQs reiterated that point. Now, let's move on to the nuanced information that we received. We have a COBRA premium assistance is available to individuals who are on an extended period of coverage due to disability, a secondary qualifying event, or state continuation, but this is only if the original event was a reduction of hours or involuntary termination. Frequently, or the Q&A number 17 addresses this, and this was a very popular question, if you will, and provides some clarity that if the original event was reduction in hours or involuntary termination, and an individual is still within their extended period of coverage, but due to a disability or that secondary qualifying event or additional state continuation, that premium assistance is available to them. Individuals eligible for standalone dental or vision would be eligible for premium assistance for major medical. So what are we talking about here? If you've reviewed the question and answer resource, or when you do, you'll notice buried in footnote number 4, it explains that eligibility for only accepted benefits does not determinate eligibility for premium assistance for COBRA under ARPA. So here, when we talk about standalone vision or dental, those are the accepted benefits for this purpose. And then lastly, an individual is not eligible for premium assistance if offered non-COBRA retiree coverage under a separate plan. And there are a few questions that address this. So I'm going to take a step back, and I should note here that generally retiree coverage is not considered involuntary termination. Generally speaking, retiring would be a voluntary termination. However, the Q&As, I keep referring to the Q&As as FAQs, so my apologies. The Q&As clarify that when a facts and circumstances test indicates that absent the retirement, so but for the retirement, the employer would have terminated the individual's employment, and the individual was aware of that, and the individual was able to continue working, that would cause retirement to be involuntary termination. So while we're here saying that an individual is not eligible for premium assistance if it's offered non-COBRA retiree coverage under a separate plan, it's important to understand that it's very limited circumstances, although it can happen, where retirement is going to fall under the bucket of involuntary termination and allow for one to be an assistance eligible individual. So retiree coverage under a separate plan, you are not eligible for the subsidy, and however, but if it's under the same plan, there's no impact to eligibility for purposes of the premium assistance. And this, of course, is contingent upon whether or not the retirement was involuntary termination. Okay, so what was unexpected? Eligibility for other coverage only impacts AEI status if the individual can actually enroll mid-year. I don't know about you all, but I really enjoyed receiving this clarification. So let's dive in to talk a little bit more about what it means to be a qualified beneficiary, and follow this unexpected guidance up with an example. Next slide, please. So as we stated in the previous slide, an AEI has to be a qualified beneficiary under federal COBRA rules in order to be an assistance eligible individual and receive COBRA premium assistance. Take it a step further, qualified beneficiary status is determined based on who has coverage on the day before the COBRA triggering event and whether federal COBRA recognizes the individual as a qualified beneficiary. So it seems as though when the ARPA guidance came out, although this is back to the basics on COBRA, it is easily glanced over, so it is great to reiterate, and the Q&As reiterate this expressly. So who are the COBRA qualified beneficiaries? Employees, spouses, dependent children, and children born or adopted by a COBRA qualified beneficiary during their COBRA coverage period. And again, those qualified beneficiaries are those who are covered on the day before the qualifying event occurred. So the employee, spouse, and dependent children covered on the day before, or a child born or adopted by one of those qualifying beneficiaries during the COBRA coverage period. But who is not a COBRA qualified beneficiary? And that would be a domestic partner with coverage on the day before the COBRA triggering event, and any covered individual that is not a spouse or child. So for example, parents or siblings that the plan may cover. So it's good just to reiterate that, and we will talk about later in the presentation what this looks like in calculating the portion of the premium that's attributable to the qualified beneficiaries for purposes of premium assistance. So next slide, please. All right, so let's look at an example that goes over the assistance that is available to potential AEIs until the individual is permitted to enroll in coverage under any other group health plan. So what we were receiving several questions related to, well, what does it mean exactly to be eligible for other group health plan coverage as it relates to the premium assistance eligibility? So, for example, if somebody is eligible for their spouse's plan, but it's not currently open enrollment and they're not able to enroll, how does that impact premium assistance? So we now have some clarification. Let's look at this for an example. We have an individual that was involuntarily terminated in October of 2020. In November, the individual had the chance to enroll in their spouse's plan. They didn't enroll. Open enrollment for the spouse's plan ended in December, and the individual has not had another chance to enroll in the spouse's group health plan at any time on or after April 1. Okay, so what's the result here? And I will point out that the summary of the slide is a good overview of the Q&A number 9 in the IRS's guidance, but the individual here is not considered eligible for coverage under the spouse's plan until the next open enrollment. So the individual can receive premium assistance as an AEI. Okay, but if the spouse's plan has open enrollment opportunities sometime between April and September, the individual will cease being eligible for the COBRA premium assistance at the point they become eligible for the spouse's plan. Okay, and then lastly, we were talking as a team, this is a little, throws a wrench in things. With the extension of certain timeframes available, if the person still has the option to enroll in coverage due to that extension, due to HIPAA special enrollment rights, they're not eligible for COBRA premium assistance because technically they are eligible for other group health plan coverage. So I wanted to point that out. Also think that the Q&As do a great job of spelling out those circumstances via examples. Next slide, please. All right, so the bottom line here is to reiterate that the goal of ARPA is to provide COBRA to those who don't currently have access to coverage. And what are takeaways? Employers should not make assumptions about whether individuals may have disqualifying coverage. It still appears, though, that someone simply eligible for Medicare is not eligible for COBRA premium assistance. We are hoping for more guidance on this, though. And then ultimately, it's up to the individual to attest their eligibility unless the employer has specific knowledge of their ineligibility. So with that, I'm going to hand it over to Beth to take us on to our third concept, talking about involuntary termination and reduction in hours.
Thank you, Diane, for those first two concepts. We're trying to trek along with the time, and I think we're doing a good job so far. And so this next concept, or concept 3, has to do with involuntary terminations and reductions in hours. And I think that this was the concept that was maybe most instructive for people, because I think this is still the subject that we get the most questions about as it pertains to COBRA premium assistance. Okay. And so instead of jumping right into the expected, nuanced, and unexpected questions, I think it's important to just start off with kind of the definition of involuntary termination that we get from the IRS guidance. Okay. And it basically means that whether there was the termination was involuntary or voluntary is really going to be a facts and circumstances based determination. And so it's not going to be a one size fits all, but instead you're going to want to understand that the IRS's definition of involuntary termination kind of involves 3 concepts. Okay. The first being that an involuntary termination is the independent exercise of the unilateral authority of the employer to terminate employment. Okay. And so this is literally, we're kind of talking about this idea that the employer has the right to kind of fire people or lay them off or do any of those things that are going to end the person's employment. However, that's also going to kind of involve this idea that they're doing so for any reason other than due to the employee's implicit or explicit request. And so an involuntary termination is usually going to mean that it's any termination that the employee is not asking for, essentially. And then lastly, there's this concept of the idea that but for the involuntary termination, the employee would be willing and able to continue performing services. Okay. I think the shocker you're going to see here is that these FAQs introduced for the first time for some of us the idea that involuntary termination can also include the employee basically quitting for quote unquote good reason. And what we see there is the idea that if the employer basically institutes some change through their unilateral authority over the employee's employment, that is going to be a negative change to the employee. That if the employee quits as a result, that's actually going to be looked at as an involuntary termination. So let's kind of jump into the expected nuanced and unexpected ideas based on that minimum understanding of what an involuntary termination is. So, first, the expected things, if you will, were this idea that, and Diane already mentioned this a little bit, but the idea that if an employee is basically given the opportunity to quit or retire or else be fired, that is going to be an involuntary termination. And I think the summary or one of the questions kind of talks about this idea of the person, making the choice to quit or retire or else face imminent termination. That's going to be a situation that's going to be considered involuntary termination because although the person chose that, they didn't really have a choice because they were going to get fired if they did not choose to quit or retire. The other expected concept was the idea that furloughs and strikes are going to be considered reductions in hours that make an AEI eligible for COBRA premium assistance, assuming that they lose coverage. Okay. We kind of expected that because of previous guidance that we received on COBRA subsidies, but that wasn't really a shocker or very nuanced. Now, to move into the nuance concepts, the first is that involuntary termination does not include an employee that quits due to concerns about workplace safety. And that might not be nuanced to you, but the question here actually goes into, I think, the more nuanced portion of it, which is this idea that although, let's say, someone who just decides to quit their job because of the COVID kind of unsafety that's out there, they might live, let's say, with someone who is immunocompromised and just don't want to risk being contracting COVID, then that person quitting is going to be a voluntary termination. However, it does go into this idea that if you have employees, for example, who the employer knows, let's say, might be disabled to where the ADA is going to apply, and let's say that that employee is going to need certain accommodations from the employer in order to be able to work in the COVID environment with what we have going on, that if that person quits because the employer doesn't, let's say, provide them with a reasonable accommodation, then that could potentially be an issue that would make it involuntary termination. So you just want to be careful there. If you have situations where the employee kind of has documented reasons, for, let's say, not being able to work in a certain way, and the employer is very stringent on not providing any kind of accommodation. The second kind of nuanced concept is as it pertains to disability. That's generally only going to give rise to involuntary termination if the employer actually terminates the person. And that's going to be while there's a reasonable expectation that they would return to work. It gets a little bit more nuanced because of the idea that someone who, let's say, is dealing with a disability who is not actually terminated by the employer is really just experiencing a reduction in hours. And so that would mean that if that disabled individual loses coverage, then they would be due an offer of COBRA premium assistance. Now, the last nuanced concept that I'll bring up is the fact that quitting due to a lack of childcare is not an involuntary termination. I think that makes sense. Again, it's kind of this idea that if the employer chooses to leave employment, then that's generally going to be voluntary. However, if an employee says, okay, I need care for my children, so I can't work, let's say, for the next month, and let's say that the employer allows them to take that time off with the understanding that they're going to return after that month when they obtain childcare, then that's actually going to be a reduction of hours if the person is not fired and they lose coverage. So, again, that's kind of a nuanced idea there of what it would mean for whether or not it's involuntary termination or reduction in hours or neither. Now, let's get to the shocking stuff here. And when I say unexpected here, it's really stuff where we're getting clarification for the first time, maybe, as well as things that are counterintuitive to what employers think. So, the first one that we'll have a brief discussion on following this is the decision not to renew an employee's contract and that's including staffing agency contracts, is going to be involuntary termination if the employee is willing and able to continue the employment relationship. But that comes with a caveat, which is that if the parties always understood that the contract was going to expire at a certain time or after the job was done, it would not be an involuntary termination. We're going to discuss that briefly. The last kind of unexpected thing goes along with that idea of employees quitting for quote unquote good reason. And the idea there is that if an employer, let's say, reduces an employee's hours substantially, or if they change the geographic location of the person's job and that causes the employee to quit, then that's actually an involuntary termination due to the employee quitting for good reason. And I really think, like I said, this is really counterintuitive to what I think a lot of employers would have thought about. You know, there might be a number of employers who had to reduce employees' hours, let's say because they did not have business last year, and they might have had a number of employees who quit because that the employer reduced their hours and they needed to go somewhere where they can work full time. Those people being AIs is kind of a game changer, in my opinion. So to move on, just to give you a discussion of the piece on contracts, I have to credit Jill Brooking on our team because she actually helped me see how this will work with the examples that we have on the page here. So the clarifying guidance on this one is that a decision not to renew an employee's contract, including staffing agency contracts, would be an involuntary termination if the employee is willing and able to continue the employment relationship. However, if the parties always understood that the contract expired at a certain time, it would not be an involuntary termination. Okay. The IRS guidance doesn't necessarily go into further explanation on this, right? But I think that they're referencing this distinction between an ongoing contract versus, let's say, one-time projects. Okay. But we also would point out that employers should consult with counsel if they're unsure about this one, because even with the examples I'm giving you, there could be other facts and circumstances based issues that make this even different. And so a couple examples that Jill Brooking gave us is the first is with teachers. Okay, so teachers are often offered contracts every year that will renew. And generally, the length of the contract might be 12 months, or it might be potentially from the fall to the end of the spring for a school year. But the employer doesn't renew the teacher's contract would likely be an involuntary termination. Okay. In that situation, the teacher is actually willing and able to continue to work, and the contract was likely renewed for a number of years. So when it's not renewed, that's an involuntary termination. But you can contrast that to the situation where, let's say, an IT consultant is hired to transition an employer from one server to another. The understanding there is that the IT consultant is only going to work long enough to complete this particular project of moving the servers or transferring the servers. And after that's done, the employer doesn't have any more work for the IT consultant, right? And so that's likely not an involuntary termination. That's likely a voluntary termination because the idea is that both parties understood that there would be an end to this. Okay, and so these are just some examples that Jill provided having to do with this discussion. But again, if it kind of falls out of that bright line understanding of it, then you likely want to consult with counsel. So, what's the bottom line on this section? The bottom line here is that involuntary termination is a facts and circumstances based decision. But I think that with the bulk of the guidance that we got from the IRS, it's pretty clear that you're going to want to scrutinize any determination that there was a voluntary termination. Unless the person actually just quit to pursue another opportunity, right? So, like if they quit because they got another job, if they quit because they just don't want to work anymore, then those are kind of clearly voluntary terminations. But if any other things happen outside of that, then you want to make sure that you're looking at and analyzing that with the IRS's guidance in mind. So then the takeaways on this is, again, kind of a lot of this guidance is counter to what employers might think about this. And I think really one of the reasons why this is kind of jarring for employers is because we're also having this discussion at the same time that we're talking about unemployment, and the rules surrounding unemployment are very different than a lot of the takeaways from this. So you want to proceed with caution in that. Also, keep in mind that if there's a situation where the person is not actually terminated, so the employer is still maintaining this employment relationship with the person, but let's say that they lose coverage because they are not working enough hours, then that's generally going to be a reduction in hours, and COBRA is going to be offered, and they would also be entitled to COBRA premium assistance. And then lastly, err on the side of seeking legal counsel if the situation is gray. because you're going to want to be able to justify the decision that is made, especially if someone feels like they're entitled to COBRA premium assistance and you're not going to give it to them. So, moving on to concept 4. This is the concept of having an extended election opportunity. And this is something that we get obviously directly from the law. And I'm going to talk about some of the guidance that we received on this subject. So, as far as things that were expected, I think Diane already brought up this idea that the person doesn't actually have to retroactively elect or pay for COBRA to make this new election. So, that's not new. We also know that the AEI can elect any coverage that they had the day before the COBRA triggering event. So, if someone, let's say, was involuntarily terminated and the day before that they had dental and vision and medical care, then they could potentially come back and elect any of those or one or two. And it would be kind of opposite if, let's say, they only had medical the day before they terminated. In that case, they would only be able to come back and elect medical. Also, the extensions of certain time frames that Diane already talked about a little bit. That guidance, if you remember, is the guidance from last year, where if you experience, let's say, a HIPAA special enrollment right, and as it pertains to COBRA, you would potentially have a year of relief because that year is basically told for purposes of those rules. But that particular guidance doesn't actually give AEIs additional time to make the election for COBRA premium assistance purposes. So they really just have the 60 days. They don't have a whole year to select that coverage. And then also, one final kind of piece that was expected because the DOL had already addressed it is the idea that there's no extended election period for AEIs that are on state continuation. And so when we talk about employees or individuals who are on state continuation and not on federal COBRA right now, you don't have to actually look back to see how long ago they were offered coverage, if you will. It's literally if they're on that continuation now, they would potentially have the opportunity to access the premium assistance, but they would not have an opportunity to come back and make a new election. So those were expected. The nuanced things are a little different, and we're going to have an example on this first one. Okay. If an employer allows AEIs to enroll in different coverage than what they had the day before the qualifying events, COBRA premium assistance is not going to be available for the coverage with the greater premium. Okay. And so if an employer does give individuals a chance to, let's say, enroll in coverage that they didn't have, then they can't choose coverage that has a greater premium. And we're going to talk about an example on that after this particular slide. Another nuanced concept is that if the plan the AEI was enrolled in prior to the COBRA triggering event is no longer offered, then the employer must place the employee or the AEI, in the similar plan provided to active employees. And this is actually, somewhat nuanced, but it also lines up with the regular COBRA rules, right? So every year when somebody has COBRA, an employer could have gotten rid of the plan that they had in place before. And generally, COBRA rules are going to require that person be placed back in the similar plan that is offered to active employees. Now, to move to the unexpected pieces, the first one is that AEIs that have disqualifying coverage will still be eligible to elect COBRA during the extended election, but they would not receive premium assistance. Okay. We've talked about this idea of kind of what it means to have disqualifying coverage, and it wasn't as clear before this guidance of whether or not someone would have that opportunity to elect COBRA, even if they couldn't get the premium assistance. And this guidance actually makes it clear that that's how that would work. And there's questions here that deal with both other coverage and Medicare that kind of make that clear. And then finally, another unexpected piece was interesting because the guidance says that an AEI can be an AEI more than once in the premium assistance period. It makes sense if you think about it, but I don't think that a lot of us had thought about that. And so the idea would be that, let's say you had someone who can elect COBRA premium assistance in April, and then let's say they get an offer of coverage from a new employer for, let's say, June and July. Let's say they get let go by the employer at the end of July and now don't have coverage for August. They could potentially also elect COBRA coverage and COBRA premium assistance for August and September. So there's nothing to stop that, but I think a lot of employers aren't really thinking about that. They kind of more look at it as a situation where once you get another job, then you just don't get the premium assistance anymore, and that's not the case. So to go on with an example of what that looks like to basically offer additional coverage to the employee and what that means, or to the AEI and what that means, The clarifying guidance on that is that if an employer allows AEIs to select different coverage, any such coverage with a premium greater than the premium for the coverage that the individual had at the time of the qualifying event is not going to be eligible for the premium assistance. And they gave an example that I think was very helpful. So in this situation, an AEI was involuntarily terminated, and then we're enrolled currently in a plan with an $800 per month COBRA premium. Okay, so the employer actually allows employees or AEIs to enroll in additional coverage or other coverage, if you will. And there are three other coverage options. One is $700, one is $750, and one is $1,000 per month. So the result of that is that the AEI in question can enroll in the $700 or $750 coverage because that's below $800 a month. However, while the AEI can actually enroll in the $1,000 coverage, if they do that, they're actually not eligible for the COBRA premium assistance. And this is to take it a step further. It's not like if what they had was $800 a month and what they select is $1,000 a month, that they just would not receive the extra $200. That's not the case. It's actually the fact that if they enroll in more expensive coverage, that they're not going to get the premium assistance for that coverage. So moving on to the bottom line and takeaways, if you will, really the idea is that anyone who experienced a reduction in hours or involuntary termination going back to October 2019 is going to be an AEI with a right to elect COBRA. So there we're talking about the additional election opportunity. But they are only eligible for COBRA premium assistance if they are not eligible for other group health plan coverage or Medicare. Okay, so let's think about this. A lot of AEIs who are not going to be eligible for premium assistance aren't going to elect COBRA, right? Like they don't want to come back and pay 102% of the cost of coverage, but they should be allowed to because they do actually have the right to do that election, okay? I also think that obviously with the examples we have, the coverage that the AEI had in place and prior to the COBRA triggering event is going to be instructive. That's going to decide, what they have to be offered, which benefits they can elect. It's also going to decide if they will have the option of having other coverage and things like that. And then one additional kind of takeaway is that COBRA premium assistance is really only available for April 1st through September 30th, 2021. Even if an AEI, let's say, continues the coverage after September 30th, that COBRA premium assistance is going to end at the end of September. And so that is concept 4. And I'm going to kick it back over to Diane to discuss concept 5.
Thanks, Beth. And for the sake of time, I'm going to go straight to it. And we have for concept 5, let's talk about the duration of premium assistance and the guidance we received. So what was So opening thoughts that we received from the Q&A. So we have that COBRA premium assistance ends upon the earliest of the following dates. First, that the date the AEI becomes eligible for other group health coverage or Medicare, the date the AEI's COBRA maximum duration period ends, or the end of the last period of coverage beginning on or before September 30, 2021. And we're going to elaborate on that. And the Q&As introduced this idea of period of coverage, meaning that COBRA that is not paid on a monthly basis could result in premium assistance starting after April 1 and potentially ending after September 30. And next slide, please. And we're going to talk about that on this slide and in an example that follows. But the Q&As, as mentioned, do a good job of giving these examples. And I will say, I think it catches you a little off guard because generally speaking, we think of COBRA premiums being paid on a monthly basis. So that being said, what was expected? COBRA premium assistance applies to the first period of coverage beginning on or after April 1, whether the period of coverage is a month or shorter. And so the question 43 from the guidance gives an example of a biweekly period of coverage. Again, this is not common. We generally see COBRA in the paid monthly, but just because it's not common doesn't mean it doesn't happen. So the examples of a biweekly period of coverage. So let's say, for example, you have a period of coverage from March 28th, 2021 through April 10th, 2021. In the example given from the IRS, the premium assistance would apply as of April 11th, and that is the first period of coverage on or after April 1. All right. And then in AEI, what else is expected? An AEI may elect COBRA to begin retroactively back to or after April 1, 2021. So we were pretty comfortable with the fact that a group health plan must make premium assistance available as of April 1, and that an AEI can elect retro to April 1. And some of the examples explain that an AEI is able to elect retro to April 1, or the election can be prospective in nature. And we'll talk a little bit more about that. What's nuanced here? COBRA premium assistance is available until September 30, 2021, but if the final period of coverage before that date goes beyond September 30, the assistance still applies. And we're going to talk about this. It's kind of the part 2 of the first example I just gave regarding that period of coverage being biweekly. So again, put a pin in that, and we're going to talk about it in the subsequent slide. And then timely payment for COBRA coverage provided after September 30 must take into account the extension of certain timeframes. So as Beth and I have both mentioned, this relief continues to play a factor in administration. So while COBRA can auto-continue with timely payment after September 30, you have to take into consideration that extension of certain timeframes, which is something to be very mindful of. And then what was unexpected? An AEI can retroactively elect COBRA and the premium assistance after September 30, as long as they are still in their 60-day election window. So question 46 elaborates on this. What do I mean by this? So an AEI can retroactively elect COBRA after September 30. And I think this makes sense, but it's not something we were thinking of. I think September 30 looked like a more hard deadline, if you will. Not that it's not a hard deadline, but let's think of the instance where somebody has a qualifying event in middle of August or early September. There is the circumstance that they would receive a notice and have that 60-day window go beyond September 30, but their coverage will be retroactive to the date of the event. So that's what the guidance means. So an AEI can retroactively elect COBRA and receive the premium assistance after September 30, as long as they're still within that 60-day election window. Next slide, please. And here we're going to take the pin out of our question regarding premium assistance that might be available after September 30th. So here we have COBRA premium assistance applies until the end of the last period of coverage beginning on or before September 30, 2021. So here we're just switching our mindset a little bit. Now, again, generally speaking, we see COBRA administered on a monthly basis, right? Period of coverage on a monthly basis. So let's switch our mindset, and while we have the set dates of April 1 to September 30, the guidance clarified that we're looking at the period of coverage that applies beginning on or after April 1 and ends beginning on or before September 30, 2021. So what does that look like? And here we have the example that corresponds with the prior example of when the premium assistance eligibility would begin. A plan provides that qualified beneficiaries pay premiums for COBRA on a biweekly basis for a corresponding 2-week period of coverage. And for September 2021, the last 2-week period of coverage is from September 19 through October 2, 2021. And the result here is that COBRA premium assistance is available through October 2, 2021. So again, shifting our mindset on this, and that we're looking for the period of coverage until the end of the last period of coverage beginning on or before September 30, 2021. So here's where we see the nuance that it could actually go a little bit beyond September 30. Next slide, please. So what's our takeaway here? COBRA premium assistance is only available for periods of coverage throughout April through September, but assistance eligible individuals are entitled to COBRA coverage until their maximum duration period ends, right? Takeaways: that COBRA AEIs can, but they're not required, retroactively elect COBRA coverage and premium assistance back to April 1. So the questions and answers give a really good, do a really good job of explaining the fact that an individual has a choice. Let's say an individual receives a notice May 1st, and their qualifying event happened a few months prior. Let's say their qualifying event happened in March 2021, and they received their COBRA subsidy notice in May. And they didn't originally elect COBRA. In that instance, the guidance explains that the individual can elect to have coverage retroactive back to the initial qualifying event that occurred in March, to April 1, or to May on a prospective basis, May 1 and forward. Any COBRA elected outside of the period of April 1 through September 30 would be paid by the AEI. So again, the COBRA premium assistance is only available for those periods of coverage through April through September, with those nuances where it would start a little after April and could go through a little after September 30th, as we just discussed. But an individual is still entitled to their maximum COBRA coverage period, but anything outside of those premium assistance timeframes would be paid by the AEI. And then lastly, the extension of certain timeframes is still relevant, as you noted from both Beth and I's comments, and could allow many AEIs up to a year to elect COBRA, even if it falls outside of the premium assistance period. Again, this is just something to be mindful of as we move forward. All right, next slide, please. I'm going to take a little bit of extra time here talking about how to calculate the premium credit. Next slide, please. Thank you. So here we have a lot of clarifying guidance from the questions and answers via examples. So as we go through some of the expected, nuanced, and unexpected guidance, we're going to hopefully solidify our understanding through examples. And so what was expected? The employers cannot receive a premium tax credit for amounts also claimed as qualified wages under the FFCRA. Said another way, no double dipping. All right. And so the guidance makes it pretty clear that an employer can't receive a tax credit for amounts also claimed as qualified wages under the FFCRA. What's nuanced? The COBRA premium assistance does not apply to covered people who aren't qualified beneficiaries. And we brought this up a little earlier in the presentation, and we're going to hopefully clarify any remaining questions that you might have that through some examples here momentarily. And what I liked this guidance for was that it clarified those questions that we were all having on whether or not premium assistance would be available to, let's say, a spouse or dependent that was added to the plan that would not be considered a qualified beneficiary. And so we'll talk about that through some examples. And then also answers the question that we received a few times today in our Q&A during our presentation is, does this premium assistance apply at the family coverage level or at the employee only level? And really, we want to, again, shift the way we're thinking about that and not think about it at the family coverage level or the employee level. We want to think about, are they qualified beneficiaries? And that the premium assistance applies to qualified beneficiaries who are otherwise eligible, meaning they have the reduction of hours or involuntary termination as their triggering events and are not eligible for other group health plan coverage or Medicare, but it does not apply to people who are not qualified beneficiaries. And we got a few pins we're going to stick in this conversation and elaborate on examples. And then what's unexpected? Here we have the premium credit is 102% of the cost of coverage only. And here, really what we're trying to point out is that we were hopeful that the premium credit would include any extra administrative costs due to administering the premium assistance via ARPA, so the notice requirements, etc. As expressly indicated in the guidance that we recently received, it mentioned the up to 2% of the administrative costs as well. And then premium credit decreases by the amounts the employer wouldn't have subsidized absent ARPA COBRA provisions. So let's talk about that for a second, and we'll go through some examples. Is that the premium credit is decreased if the employer is providing a COBRA subsidy. So we have several examples that hopefully clear up any confusion that statement just caused. And then overall, we're looking at the premiums not paid by AEIs is what the amount of the premium assistance credit is made up of. So if we keep that overarching thought in our mind, I think it helps clarify these examples that we're going to go through. So next slide, please. All right. So as I promised, we have several examples that will be hopefully helpful now and hopefully helpful for future reference as you are administering questions related to this topic. But here's the guidance. COBRA premium assistance does not apply to the portion of the premium related to continuation coverage for individuals who are not qualified beneficiaries. So now we're going back and illustrating what that means. So let's take example 1. An employee covers herself and her 2 dependent children on COBRA. The employee also covers her domestic partner on COBRA. The coverage for self plus 2 or more dependents is $1,000 a month. So what's the result here? Premium assistance amount is $1,000 because the AEI covers herself and 2 children, and they're all AEIs. The domestic partner is covered, but the coverage for that person would not cost the AEI any more than the $1,000 that it would have taken her to cover employee and children. Now, example 2, we have the same facts as example 1, except the employee only has 1 dependent child on COBRA, and the premium attributable to that self plus 1 dependent coverage is $800. The premium for the employee, child, and domestic partner is $1,000. So here we have a different result. And since only the employee and child are AEIs, the premium assistant credit would only be $800. All right, and the employee would be responsible for the $200. Example 3, an employee is an AEI with self-only coverage costing $450 a month. The employer has open enrollment in June, and the AEI adds their spouse and child who were not covered before the AEI's involuntary termination. Spoiler alert, the spouse and child dependents are not qualified beneficiaries. So family coverage is $1,000 a month. And the result here is that the spouse and dependent child are not AEI, as I just alluded to, and the credit is $450, and the employee is responsible for $550 for the coverage of the spouse and child. Bottom line here is that the premium assistance is not necessarily tied to the level of coverage in which you're enrolled. It depends on whether or not who is being covered is a qualified beneficiary. Next slide, please. Now let's hammer home the guidance on the amount of, or regarding if the amount of the credit that would be the subsidized. So I'm not saying that right. So I'm going to go straight to what's on the slide. The amount of the credit is the premium that would have been charged to an AEI in the absence of premium assistance and does not include any amount of the subsidy that the employer would have otherwise provided. In essence, we're going to that overarching mindset of the amount of premium assistance credit is the premiums not paid by the AEIs. Let's look at our examples. COBRA premium is $1,000 a month. The employer normally requires qualified beneficiaries to pay $500 per month and subsidizes the other $500. The result here is that the COBRA premium assistance is $500, not the total cost of coverage. So this kind of bucket of information fell into that unexpected, as we received quite a bit of clarity through the Q&A regarding the amount of premium assistance when there is employer subsidy provided. Example 2, the applicable COBRA premium is $1,000 a month, and the employer provides severance that allows qualified beneficiaries to pay the same monthly premium as active employees for 3 months, let's say $200. But after those 3 months, the qualified beneficiary pays $1,000. And the AEI terminates in March 2021. The result here is that the COBRA premium assistance for the first 3 months is only $200. The COBRA premium assistance goes up to goes up to $1,000 in July, August, and September. And then lastly, we're looking at the same facts as example 2, except that the employer doesn't actually offer COBRA until 3 months of severance have passed. For the first 3 months after termination of employment, the terminated employee is treated as if they're active and pays $200 for coverage. So very similar to scenario 2, but different in the way it's administered, and it makes a difference in the result. And so the AEI here terminates in April, but COBRA doesn't actually begin until July. And the result is that the COBRA premium assistance, as you might have guessed, for the first 3 months is $0. But COBRA premium assistance in July, August, and September is $1,000. So next slide, please. So here, the bottom line is the amount of the COBRA premium is no more than what the individual would have paid for COBRA continuation if there was no COBRA premium assistance. So a lot of helpful information to keep in mind here. Non-qualified beneficiaries who participate do not receive COBRA premium assistance, as we've talked about throughout this presentation. Employers with individuals on severance or furlough would need to proceed with caution on claiming the entire 102% if the facts don't reflect that that's the entire amount that the COBRA premium that the individual would have paid. And then employers really should consult counsel before assuming that they can claim the credit for furloughed employees who never lost coverage. And so that being said, I'm going to hand it over to Beth to take us on our last 2 concepts, starting with how to claim the premium credit.
Thank you, Diane. And I will say these last 2 concepts will go by a little bit quick because it's like tax stuff, right? But I just want to put a pin in that guidance on severance and employer subsidy, because we know from receiving, let's say, 3 months worth or a couple months worth of questions from employers that a lot of employers are looking at this as a chance to get that entire amount of COBRA paid by the federal government. And that guidance on, COBRA subsidies provided by employers makes it clear that you may not get that whole 100%, right? And so we just want to make sure that as you are going through and claiming those credits, that you are mindful of the fact that if you were offering, let's say, a severance agreement to someone and you were going to pay for all of their COBRA, that the government is going to look at that as you were going to pay for all of their COBRA. Like, that's a big thing. But I just want to kind of reiterate that before moving on. Now, going to concept 7, that's how to claim the premium credit. And we've gotten a couple questions about this. The guidance here was not super nuanced or different. So for example, we expected that the premium paid was going to claim the credit by reporting it and the number of AEIs on their Form 941, which is a quarterly federal tax return. And so that was very much expected. But we did often get the question about, let's say, premium payees who, let's say, didn't have or don't have a lot of Medicare tax that they pay, and kind of what happens at that point. And the guidance goes on to mention that a premium paid can reduce its deposits of federal employment taxes in anticipation of the credit as of the date the employer is entitled to that credit. And so in situations where, again, the Medicare, let's say, tax amounts are not that much, they can also kind of do that. And then there's also kind of the idea of those advance credits, if you will. Now, what was more nuanced is that the premium payee is entitled to the premium credit in any month after the AEI makes the election of the COBRA, and then they're entitled to every basically subsequent period of coverage, right? And so that really spoke to the idea that once the AEI actually elects the COBRA, that is when the employer can begin to claim that credit. And so some situations where there is retroactive, you know, installation of that coverage, it's really going to depend on when the person made the election. And then the other nuanced thought is that if an AEI fails to provide notice of their ineligibility, due to disqualifying coverage, the premium payee is not required to refund the IRS for the premium assistance credit that comes from that disqualified period. And so this is really getting to the idea that if you have an employee or an AEI, who is not honest about having disqualified coverage, and let's say that the employer finds out about that after they've already claimed the credit for that COBRA, the premium pay doesn't have the obligation to then, let's say, go back and refund that money to the IRS. The understanding then is that that individual could be subject to penalties because of being dishonest. Okay. And then the last kind of unexpected thought here, and I don't even know how this works from a tax mechanism, but we got the question a couple times of whether or not the premium assistance credit is included in gross income. And the answer there with that question is that it is included in the gross income of the premium payee or the employer in a lot of situations, but it is not included in the gross income of the AEI. And so we didn't quite know how that works. Again, if any of you tax people out there kind of know how these type of credits work, I would assume that the gross income is going to be, let's say, canceled out by the fact that the person received a credit. I don't know how that works, but tax wise, I'm sure that employers kind of will not necessarily be hit by providing this guidance, but you would talk to your accountant about how that works exactly. Not really any examples on this as much as we have kind of a bottom line and takeaways. Because this is a tax issue, employers are going to work with their accountant to claim the COBRA premium assistance tax credit. And then that's, the mechanics of how it all works. Again, it is part of tax. Okay. And so they're going to want to seek out assistance from their accountants, especially, like I said, in situations where, let's say, small employers have, a Medicare tax liability that is not quite high enough to actually reflect all of the premiums that are paid by the employer as the premium payee. And then finally, the IRS has already provided some clarifying guidance on how this tax credit will work because it's similar to how they worked for FFCRA payments. And so we've actually gotten, I think, a couple times this year already, a bit of guidance on kind of the mechanics of this and how it will work as far as utilizing the tax forms in question. Now, going to the last concept, and y'all have been rocking with us now for over an hour, and we're getting through it. But the last concept that's addressed is substantiation of the premium credit. And it's interesting because the guidance we get here is actually included in some of the other sections that we've already discussed. But I wanted to pull it out because we get a lot of questions about it, and I want to address it in a way that makes kind of clear what the guidance is telling us. Okay. So the first idea of what's expected or what we expected from this guidance is that a premium payee must keep records of an individual's attestation regarding their eligibility. That makes sense, right? Like if you're claiming a premium tax credit, the IRS is going to generally want you to have records to show that you're actually entitled to that premium tax credit. And so that is not, or that premium credit. So that's not going to, I think, shock any of us. But it does get a little bit more nuanced in how an employer goes about substantiating the premium credit. Okay. And so the first nuance concept is that premium pays can require AEIs to provide certification or attestation as to eligibility for the premium assistance, and they must retain that certification or attestation in order to claim the tax credit. Okay. And so there's this idea that the reason it's somewhat nuanced is because the questions and answers are actually written to say that the premium payer doesn't actually have to require the certification or attestation, but they can only get the premium credit if they require it or if they have it. And so, it's kind of interesting because I guess there might be some phantom premium pays out there that don't want to get paid back. In which case they could, not require a certification or attestation. But for, I think, the vast majority of premium pays who are going to want to get paid back, they need to have those documents. Also, Premium pays must retain records documenting their eligibility for the credit. And this is going to be, the documents that we've already discussed as far as certification and attestation. And the guidance makes it clear that if the IRS asks for this documentation and the premium pay doesn't have it, then they're basically going to go back and pay those employment taxes that they didn't have to pay back. Okay, and that generally is how the IRS is going to, operate as it pertains to any kind of operational failures having to do with plans and tax credits. So I can't say that that's a shock, but it does basically let us know that, okay, you want to document this so that you don't end up getting hit with the taxes that you are, basically taking advantage of. And then the piece that I think is unexpected, and I pulled it out from the nuance section because I kind of want to be very clear about, I think, the argument that our team is making here. Um, the guidance gave us a couple questions, question and answers 4 and 5, that say that an employer can require the AIE or AEI both to certify that they're actually eligible due to an involuntary termination or reduction in hours, and that they don't have disqualifying coverage. The reason that I said that this was somewhat unexpected is because that first piece, where the employer is requiring the AEI to certify that they're eligible due to an involuntary termination or reduction of hours, should be something that the employer already knows. Like they already have probably documentation showing whether or not that person was involuntarily terminated or had a reduction in hours. But the guidance does make clear that an employer could actually require someone to attest to that or to certify that. And so that's a little interesting. I think the second piece, which is that they can require them to certify that they don't have disqualifying coverage, makes sense because the employer may not necessarily have the knowledge that the person automatically has, disqualifying coverage or not. Especially if you consider the situations where, an employee who might have left your employment might not tell you where they're going or, if they have a job currently, you may not have reason to know that. And so, with those concepts in mind, let's kind of do a bottom line here and just talk about some of the takeaways. So, the bottom line is that employers will need to maintain AEI attestations and records reflecting their eligibility in order to claim the tax credits. And so, documentation is going to be key here because even let's say if the IRS doesn't come asking you for it immediately, if they ever do ask you for it in the future, then you need to provide it. Okay. Now, we also know that employers should request attestations, right? At the very least, like that is something you should ask the people to attest that they're eligible for the coverage and they don't have disqualifying group health plan or Medicare. Now, when we say that you can require those attestations or certification, if the employer has records indicating that the AEI actually did experience reductions in hours or involuntary terminations, then you probably want to proceed with caution in like forcing the AEIs to confirm their eligibility. Like if you already know that they're eligible, then you don't want to say, oh, well, no, you can't prove to me that you were involuntarily terminated, so you're not going to get this assistance. That's probably not going to go well. And so you want to be careful here. And I think the next point is what we're getting to here. The goal of substantiation should really be to prove that the employer, to prove the employer's right to the premium credit, but it shouldn't serve as an impediment to AEIs receiving the coverage to which they're entitled. Okay. We've gotten, let's say, questions from employers here and there who are clearly seeking to limit how many people take advantage of this credit. And that's really not the spirit of the law. And you want to be very careful if you're putting any, obstacles in place to where an AEI is not able to easily attest or certify, their eligibility. And then finally, we also get the question, how long do we have to keep these documents? The IRS generally is going to have a 3-year statute of limitations on tax filings. Now, obviously, work with your accountant to, determine how long you need to keep records. And many of your employers or companies will have rules on how long records need to be maintained. Okay, and so definitely comply with any of those rules. But just keep in mind that the IRS, if they have to come and ask you about that, could likely ask for it for 3 years at least. So those are the 8 concepts, and that's a lot of information. And we already know that some of you are going to have to come back to this. Some final thoughts on implementation. Obviously, this guidance helps us and employers answer some of the unanswered questions that we had following the original law and the DOL guidance. Okay, so we do have some unanswered questions that were answered. Okay, we also have some unanswered questions that are still there or additional unanswered questions that we might have got from this guidance. And so, continue to follow what comes out. And I think that, we may see at least one other time where we see the government come out and kind of clarify things. Okay. Another point is that, we received this law in March, and we got guidance from the DOL in April, and now this guidance in May. And so a lot of you as employers have already, let's say, sent out notices to AEIs because your vendor probably required you to provide certain information in early May to get those sent out by the 31st. But some employers are going to need to kind of readjust their approach if your prior understanding of the rules don't line up with the guidance we got. And so keep in mind that you're going to want to make sure that you reapproach that if it's necessary. Okay. We did get a question in the Q&A about kind of vendors and whether or not they received this guidance, and they did, but we all got it less than a week ago at this point. We do expect that vendors are going to reach out with any necessary updates based on the guidance. But I also think it's important to point out that generally the employer is going to be responsible to offer COBRA, and that vendor is just assisting you. So when it comes to fiduciary duty, if you know that there need to be some changes made, it's going to be incumbent upon you as the employer to do that. And then finally, remember that the requirement to provide this COBRA premium assistance continues through at least September. Okay, we know it goes to the end of September for now. They might increase it, but I say that because many of you will work to send out this initial set of notices, but this is going to be ongoing anytime that you terminate someone or have someone experience a reduction in hours from April through September. So it's not going to be over in that regard. Now, we got a few minutes left. We always try to include resources. So here we have links to all of that, and you're going to see some things coming out from our team in the coming days, in addition to being included with the recording of today's presentation. Jill, you got anything for me in the couple of minutes that we have?
Yeah, so I will just say there tended to be a general theme on how much involvement an employer has and how much responsibility. And it's kind of like with the Form 1095Cs and COBRA administration. It's wonderful that we have vendors and administrators that take a lot of the administrative burden off of employers. But remember, at the end of the day, bottom line, employer plan sponsors are fiduciaries to the group health plan, and you are responsible for monitoring vendor action, and you are ultimately responsible, especially if your plan is subject to federal COBRA, for claiming these tax credits. So just because you have a COBRA vendor that's helping send out these notices, you still need to be involved. The vendor will need to know which individuals were involuntarily terminated versus reduction of hours versus divorce versus whatever. And you're the person who has that information. They're not going to know that. And your choice, will you allow these AEIs to change their election options to a cheaper medical plan, for example? That's an option. You need to tell the COBRA vendor whether you're doing that, because that changes what information will be in the notice. And then at the end of all of this, you're going to have to maintain records and attestations and certifications and know how much to claim as a tax credit, because you're going to be the one filing those quarterly returns. So yeah, it's wonderful that we have COBRA vendors, but that doesn't take all effort and all responsibility off of our clients.
Thank you, Jill. And I think that's a good place to end it out. Now, I alluded to resources that we have. And again, you'll see some things come out. I know that our compliance corner will be coming out tomorrow. It'll have a longer article on this subject. Our podcast will be coming out tomorrow. We'll have more on this subject. And so keep in mind that, this is something where we're providing as much information as possible. And honestly, a lot of us are going to have to approach this more than once because it was a lot that we just got last week. So with that, Leanne, I'm going to turn it over to you to close this call out right on time. Thank you, everyone, for attending.
Fantastic. Thank you so much, Beth, Diane, and Patrick, for sharing your valuable time and your expertise with us today. Thank you also to Jill Brooking and our benefits compliance team for moderating and answering the Q&A. As a quick reminder, today's presentation was recorded and will be emailed out tomorrow. The recording and slide deck from this webinar will also be posted to the nfp.com latest insights page under the webinars/training section. That concludes our webinar for today. Thank you all so much for joining us, and enjoy your day.